In order to sign a power of attorney, a person must be at least 19 and capable of managing the person's own affairs. So it has to have that, and it's difficult to define when are you capable of managing your own affairs, but it's one of those things you recognize it when it's there, and when it's not there, you recognize it's not there. And that can be too high a capacity test for some. So we have the representation agreement concept. Now, we're going to talk about it in the context of healthcare, but it can also apply to financial decisions. And if your child does not have sufficient capacity to grant a power of attorney, you would probably do up a representation agreement that covers both finances and healthcare. Mm-hmm. We're just going to talk about it in the context of healthcare, just to organize the discussion. So do you want to?
Mm-hmm. Yeah, so there's two types of representation agreements under the legislation. There's one that's a Section 7, which is just because it's called Section 7 that covers it, and then there's a Section 9. And Section 9 has a little bit of a higher capacity test and a little bit more powers that are given to the representative. Section 7 is a simpler capacity test, so that's the one that we're going to focus on because capacity is a common concern. So the Section 7 are a little bit more simple, as I said, a little bit less powers. They cover routine matters only, and you don't need to involve a lawyer to have a representation agreement under Section 7, and the capacity test is easier, which we'll get to in the next few slides.
Now, you don't need to involve a lawyer, but it's probably a good idea to involve a lawyer because then you've got a professional witness who says that the person meets the Section 7 capacity test, and it might be good to have that person who can say that at the time this person signed the agreement, they had the capacity to sign the agreement, because the capacity test is quite different for the Section 7
when compared
agreement.
To a power of attorney.
Yeah. Mm-hmm. The nice thing about this legislation is capacity is presumed. So if somebody is alleging so-and-so did not have capacity, they have to prove that the person did not have capacity. And that's a nice reverse onus shift because, again, it's a gray area. Do you have capacity or not? And often, it's, in some situations, it comes down to the burden of proof. And if I have to prove you don't have capacity, that's sometimes hard. That's different than if I had to prove that you did have capacity. It's sort of like, the replays on sporting events. For the replay to overturn the call on the field, it has to be conclusive evidence. And sometimes you look at the replay, I have no idea where the football is. So the call on the field stands. So if you presume capacity, and you're doing the replay and you say, I have no idea if it's capacity is presumed. So that's good. That's helpful. You don't have to have a medical determination or a legal determination, but it's useful to have that independent evidence. And capacity is a legal concept, not a medical concept. Now, if capacity is in doubt, we will sometimes, if I've determined that the person has capacity, I will sometimes get a psychomedical examination to confirm that, where they have the person do a battery of tests and, the clock test, and you draw the clock and that sort of thing. That's useful as additional evidence to confirm. But really, capacity is a legal distinction, and I make the judgment on capacity by talking to the person, asking questions, see how they react. We have this idea that it's a medical determination, and medical evidence can say that there's dementia. Somebody might have dementia, but they might still have capacity for certain things, and they might have capacity on certain days and not have capacity on other days. So the question is, when you sign the document, do you have the capacity to do that specific task? There's a lower capacity for certain things, high capacity for will, but a very low capacity threshold for the representation agreement. So, factors to consider. And this is from the statute, so you can see how it's a easier test. Does the person communicate a desire to have a representative make or help make decisions? So you have to recognize that you might need help. Pretty easy threshold to make. Does the person demonstrate choices and preferences? Yeah, I'm comfortable with my mom and dad. I'm not as comfortable with other people. I can't figure out other people. That's a preference. Can the person express feelings of approval or disapproval of others? Yeah, I like my mom and dad. Don't like the neighbor. That's good. Is the person aware that making, changing, or revoking the agreement means that the representative may make or stop making decisions or choices that affect the person? You know, that's a lot of words, but if you sign this agreement, your parents can help you out. And if you don't sign the agreement, they can't. Oh, well, I want my parents to help me out, so yeah, that makes sense. Does the person have a relationship with the representative that is characterized by trust? And this is going to be the important one. Does it make sense for this person to appoint this other person? Once had a person, and this was an older person, but she had dementia, and she was in my office, and she and her daughter had traveled down from the north part of Vancouver Island, and they lived on one of the islands off the coast. And so I asked her about, she had obviously taken a ferry to get to my office, and I asked her about the ferry. Oh, no, we didn't take a ferry. So obviously a capacity issue. But then I started talking about her and her daughter. Oh, yes, my daughter is so good to me. She takes such good care of me. So there's a relationship of trust. And so we established that relationship of trust. We did the Section 7 agreement, and it was not challenged by anybody. And it put the daughter into a position where she could do things for her mother and deal with her assets. That was a financial and healthcare document, because we couldn't do a power of attorney because the mother did not have the capacity to do that. But the representation agreement fit right in there. So that was good. A good thing that the government has done. Okay.
So if you can't pass the capacity test, even that a little bit more simpler one from Section 7 of the Act, then you have to go to the Supreme Court and you have to have a committee established. One person can be a committee, so it's a little confusing because of the word committee, which makes it seem like people working together. But just one person can be a committee, and it's appointed by the court.
And it's a terrible process to go through because you have to prove that the person doesn't have capacity. So it's always better to get that Section 7 agreement in place as soon as possible, so you don't have to go through the court process, because it's expensive. The judge is going to be sympathetic, but the judge is going to say, I need to make sure that this makes sense. And you're going to have medical. It's painful to go through just because of the stuff that you have to prove. So if you can avoid that, because you have to declare that this person is incapable of handling the child's own affairs, and that's difficult. You want to prove it, but you don't want to prove it. You have to notify the public trustee, because the public trustee is the guardian of the children of the province, because that's goes back to the royal prerogative of taking care of the youngins. And you will have to work under the supervision of the public trustee. Public trustee does charge fees, but the more problematic thing is that the public trustee is overworked and understaffed. So it's going to be a frustrating process working. They're good people, but they're overworked and understaffed, so it's going to be a frustrating process. So if you can avoid it, it's a good thing to avoid.